Good morning, guys. Today we'll continue with our discussion on the loan sale, and we will talk about option money versus earnest money. Okay, so let me state, for example, I offer to sell to you my only car for a price of 50,000 pesos, and you are given 1 week to think about it. So you said, "Thank you, sir, for the offer. Thank you for giving me 1 week to think about buying your car for a price of 50,000 pesos." 2 days after, I said I changed my mind. Sayang ang car. So I said, I call you and tell you that I'm no longer selling the car. Can I do that? The answer is yes. Uh, the seller can withdraw the offer anytime before the expiration of the offer period. So how can I be bound by my offer? So I can be bound by my offer if you pay the option money. So let's say, for example, I offer to sell to you my only car for a price of 50,000 pesos, and you are given 1 week to think about it. And you said, "Thank you, sir, for giving me that option. Here's 20 pesos as a payment for the option." So can let's say, for example, 2 days after, I changed my mind and I said, well, I'm no longer selling the car. Can I do that? This time, the answer is no, because option money is already given. There's already 20 pesos as consideration for the option. I can no longer withdraw the offer anytime before the option period comes. This in this example, before 1 week expires. So I can no longer do that. So here's the thing: when we talk about option money, it simply means it's a consideration for the option. Is it an evidence for the perfection of the contract of sale? The answer is no. So what if, for example, I offer to sell to you my only car for a price of 50,000 pesos, and you have 1 week to think about it? And you said, sige sir, I will pay you 20 pesos for the option. So an option money is already given. So before 1 week expires, you said, sir, I decided not to buy the car. So can you be liable for breach of contract in that case? The answer is no, because the consideration that is paid, an option money, is not an evidence of the perfection of the contract of sale. It's just a consideration for the option. So, on the first place, by paying the option money, it's not, the contract of sale is not yet perfected. So, it's perfected when you decide to buy the car. So, you cannot be liable for breach of contract if you pay the option money, when you pay the option money. Okay, so option money, as I have said, it's not an evidence of the perfection of the contract of sale. It's not part of the price. Okay, and so therefore, the seller nor the buyer will become liable for breach of contract. So let's say, for example, I offer to sell to you my only car for a price of 50,000 pesos, and you are given 1 week to think about it. Then you said, sir, I will buy the car. And in advance of that, I will pay you 20 pesos. Okay? Don't wait for 1 week, sir. I have already decided to buy the car. And here's 20 pesos as a down payment. 2 days after, I said I changed my mind. I will no longer sell the car. So, can I be liable for breach of contract? Okay, the answer is yes, because the 20 pesos is not a consideration for the option. You said it's a down payment for the price. So this time, the 20 pesos is no longer an option money, but an earnest money. Okay? So, since an earnest money is already paid, it's already considered to be a down payment. Okay? It's now an evidence of the perfection of the contract of sale. So if I say I am no longer selling the car, then because a contract of sale is already perfected, a down payment has already been made, then I will become liable for breach of contract. All right? So, what if, for example, you say, here's 20 pesos as part of the down payment of the price. So, earnest money is already paid. Then, 1 week comes, you said, Sir, I don't have enough money, so I will no longer buy the car. Can you be made liable for breach of contract? The answer is yes, of course. Because by paying the 20 pesos, as a down payment, it's already considered to be our earnest money. And so therefore, contract of sale is already perfected. So if you decide not to buy the car anymore, not to continue with the balance payment of the car, then you will become liable for breach of contract. So you take note, guys. Here's the difference between option money and earnest money. When it is an option money, it is a consideration for the option. It's not part of the total price of the sale. It's therefore it's not an evidence of the perfection of the contract of sale. Therefore, if the buyer will not pursue with the purchase, the buyer is not liable for breach of contract. Okay. If earnest money is paid, it's already considered part of the price, and so therefore it's considered to be it's considered to be a down payment. And since it is considered to be a down payment, contract of sale is already perfected. If the seller will withdraw from the sale, the seller becomes liable for breach of contract. And if the buyer will not continue with the payment of the price, then the buyer will become liable for breach of contract, since the contract is already perfected. So these are the differences, guys, between earnest money and option money. Bye, guys.